Well, our thoughts are obviously that we're disappointed with the result. The vote was in favor of making the proposed changes in total, and that went through. Essentially, as a team, we looked at a lot of the issues in a comprehensive manner. We took a very strict approach, looking at the reforms that were in motion and looking at what was being proposed. In particular, there were two aspects I think that we took some issue with. Those particular issues being one, the vote. The vote was being extended as a business ratepayer vote, and another to the residences of the city, and that applies in both corporations, to the Corporation of Hamilton as well as the Corporation of St. George. And also looking at a particular clause, which was clause or section 14, which dealt with looking at previous contracts that concern land, leases, anything over 21 years, and the ability of the government to retroactively go back and effectively cancel those particular contracts if they deem necessary. And so, of course, we had some general concerns, starting with the ratepayer and that portion of the legislation. And we were looking at primarily the right of businesses and their ability to vote. And so understanding the pros and the cons on both sides, there's question marks. And we've looked at, obviously, businesses, and the argument that's been put forward by the government is that businesses should be entitled to have a vote, as they are taxpayers in the city. And also, as a matter of collaboration, also from a perspective of being inclusive. And I think the key word that they were arguing was inclusive. And so the question then begs, well, what other jurisdictions have this type of scenario or system set in place? And so, of course, the government had relied on certain examples. I believe that Saskatchewan was mentioned, the City of London, which differs from Greater London, and other areas in Canada. And so the first argument is that, well, there's precedence that this type of hybrid, as the government has called this type of voting regime, to be put in place. But there are other precedents of other jurisdictions, like New York City, which is a very large metropolitan environment, perhaps considered one of the leading financial markets in the world, perhaps outside of London. And in that particular city, the residents of the city are the ones who would vote for the mayor. And so one could say, well, if that works in their jurisdiction and their setup, why do we need to alter what we have in this jurisdiction? And so there's arguments on both sides of the table for it. I guess our concern is more from a historic perspective, but also looking at, in context, the power of people and the right to vote. Businesses inherently are going to operate on a different modus operandi from individuals. And so businesses are looking at bottom line profits. They're looking to appease to shareholders and make sure that those aims and objectives are met. And some of the concerns that we looked at, trying to take a pragmatic approach of the way that the government had put forward the particular legislation. They were trying to alleviate or anticipate concerns in advance by suggesting that the businesses would only be entitled to one vote. Now, for example, I own I'm the primary shareholder of 6 different companies. In my group structure, and having one physical office in the city, one might say that notwithstanding I have 6 different companies, as a ratepayer, I would be entitled to one vote. I guess the question then begs, what happens, and there are other scenarios, we know of this, certainly when we look at the politicians themselves, when we look at the register of interest and what kind of shares or interests politicians have, one may see various different companies actually set out. So it's possible for me, Mark Daniels, to actually have majority shares or interests, controlling shares, in a myriad of different companies. So, for example, if I owned the law firm on the corner, the bakery shop down the road, the gas station, the cycle shop, the mail delivery company, that's a number of different businesses that would be entitled to vote, and I would have to effectively pick a proxy, someone, whether it's one of my employees, but someone associated with the business that would actually go forward and make the vote. And so where the businesses wield a certain degree of power, and this is some of the concerns where we say we see a dilution of the residents' vote, is that the businesses and the business owners can then start to effectively have more control. And I don't think that was either thought out or it was thought out and very craftily put in a particular way where hopefully the point would be missed. I mean, that's going to be a matter to see, I guess, with time and for the politicians to answer to directly. We did try and ask those questions, but some of the answers were not given. As it relates to looking at, just sticking with the theme of the business vote, what was the past? And so we look at a piece of legislation that effectively started from 1923, and for about 9 decades, that piece of legislation continued unabated. There was no protest for reform and change within that period of time. Then in 2010, the previous government, the Progressive Labour Party, had decided that it would be necessary to start to effect more reform with a view of good governance in place. And what's very interesting is that we saw a lot of protest. There was corporation money that was being dedicated, admittedly so, by the previous mayor, spent on trying to put together a campaign, and effectively it said that the PLP was seeking a land grab. And of course, there was a lot of concern about what that meant and whose control and everything else. What's very ironic is that the previous legislation actually didn't have any provisions in it that could be considered a land grab at all. Whereas this legislation that we're dealing with now, when I come to Section 14 and other related sections, actually does deal with the disposition of land. And so it's ironic that there was a massive protest in one context, but not now. Now, our role today was nothing to do with the current or previous administrations as they relate to the Corporation of Hamilton. We're not trying to articulate or advocate on behalf of any individuals. We don't have any preference of individuals and the like. My personal observations, and it's been remarked by other members and colleagues within my party, is that there seems to be a systematic approach, a campaign that's taken place since January of 2013, since the election, really looking at the current administration. And one might say that there's been attempts to malign characters, attack integrity, or whatever the case may be. And I think we have to look at the bigger picture. And ultimately speaking, I've seen some of the blogs and the comments. Individuals have said, like, this is a 262-year lease, this is Bermuda land, we have to be protectionist, we have to look forward to the future and consider future generations, and all that's absolutely true. No one, I think, is arguing with that. I think where we have some concerns, however, is that when you have a government, and a government changes from one to the next, and the new government is starting to look retroactively at contracts of the past, with a view to passing law to say that we'll have the ability to cancel those contracts, knowing that there would be breaches of contracts and claims can be made and damages can flow from it. And knowing that we're talking about the consolidated fund of where the funds would come from to pay any damages, there's a genuine risk that the taxpayers could be suffering more by being exposed to further settlements down the road. All this will come out in the wash in due course. But effectively, when we're looking at what's in place, there are overseas investors. We've certainly heard with the current tender that's been put out and the current lease and development, the information that we have been given is that there's a primary developer here in Bermuda. There's opportunity for various other businesses in the city to benefit from large-scale development. It's certainly not something that's going to be encompassed by one entity alone. And as it relates to going forward down the line, you have these overseas investors. And so there's been talk of about $1.7 billion that's been earmarked for this particular redevelopment. And so when we look at $1.7 billion, that's a significant amount of capital. When we look at the fact that there's overseas investment that is willing to provide the funds for that or has suggested that they're willing to earmark the funds, one has to then kind of weigh up, well, is there a reason or rationale for such a period of time, such as 262 years, to be associated with a development of that considerable magnitude and considerable money being injected into the community? And then how is that money going to be recouped in the return on investment? So all those are factors to consider. Now, the amount of 262 years, we could look at that and say perhaps it should be 100. I don't know the particular facts, but any kind of suggestion that would be an under 21-year lease would seem a little bit difficult to resonate and make sense of. So in any event, I understand some of the arguments that are being forward. I think the concern is if the government was saying we want to pass legislation to make a more streamlined process so that the representatives of the people, which is the work that takes place in the House of Assembly, would actually like to look at contracts going forward and have more of this good governance and dialogue. I understand that, and I get the spirit of that, and I would support something like that. The concern I have is that for these investors in this particular case, or other investors looking into the country, there can be genuine concerns as to the viability of us as a good government if we allow for contracts to be rescinded in this type of manner. Investors might lose some confidence in Bermuda as a jurisdiction and also might lose confidence in the political system that we have. I believe that the Shadow Minister of Finance, MP Burt, had spoken on this and referred to a particular company that does go around and do political studies and evaluates various countries and looks at all the factors of how stable an environment is. And one of the criteria they would look at is how do countries and politicians deal with laws in subsequent manner. And I think this raises that concern because although it's not a foregone conclusion at this stage, there certainly is the potential for this government to rescind a contract which might have some significant cost consequences for us as a society going forward. And I think when we look at the whole process holistically, the argument about this inclusive mindset, we have to really weigh up the benefits. I think that for many years, the corporation, we've heard this discussion about it's not a land grab. We've heard discussions about getting away from a land or a property vote. And so we have to ask the questions, why? Why would we want to get away from a property vote? Well, with the Progressive Labor Party, we've certainly championed a cause of one man, one vote as it relates to the general elections, and we've seen discourse in the past about how our political landscape before, historically, was one where individuals had multiple votes and there were various criteria involved. And we all seem to agree at this stage in 2013 that that's a wrong system and it should be a balance of just one man, one vote. And so when we look at the land vote or the property vote that happened in the past, one would say, okay, if it's wrong for landowners to be able to exert more power and influence by having multiple votes, where then does the difference lie for businesses? Although it's being positioned in a way where you have one vote, where the cumulative effect is that certain individuals or groups of individuals can benefit through the power of multiple business votes, does that dilute the residents' vote? And so although it's not directly taking away the power of the residents, it does dilute it. I also made a comment in the Senate, and it's a theme that we championed, is that for so many decades, we've trusted the individuals who have been at the helm of the Corporation of Hamilton in particular to do their job well and to take care of the residents' interests at heart. And I think that that has been a delicate balance to do, and I don't want to make any criticisms of previous administrations. There's always a work in progress. But there was some commentary about the need for this inclusive relationship between businesses and the residents and having the power of the vote. But I think it's also important to distinguish that where the residents make democratically sound decisions, they've exercised their vote and their opinion, then that should be respected, and there should be a degree of trust as a society that their vote would carry just as much weight as the votes in the past. And I think that when we look at things going forward, the main issue right now is the waterfront. That this whole discussion, certainly one of the lenses that we've looked from, is a question mark with the specific reference to the contracts after the 1st of January 2012 being a very specific reference to any contracts emanating from this waterfront development. And there's certainly individuals in this country who would like to be in pole position to lead that particular development. And we don't know at this stage whether special interest groups have had their say in trying to push this legislation forward. One of the concerns of why we've even come to that particular position is the whole question of the urgency of now. The government has said we want to come into this legislative session to push forward more legislation, and we welcome that. We're not here to oppose that in the slightest. The issue, though, is that when we look at this particular legislation, it doesn't create any jobs. And so one of the questions are, why now? Why is this being pushed so hard right now? Especially when we consider a piece of law that's been around since 1923, and there hasn't been massive protest for the reform until a previous government made certain changes, and then a new administration has come into power, which may not resonate with administrations of the past. And I think that there seems to be some battling of the minds and hearts as to who should be in control or not. That's not a decision I'm really trying to make any hay out of. But in terms of the democracy, the democratic process, and having a very sound jurisdiction, I want to defend that to the tilt. And that's why we were against the legislation being brought forth in this manner. So, thank you.